In this video we're going to look at the terms of a contract, and in particular looking at the restrictions on the terms of the contract. Sometimes contracts may attempt to exclude certain circumstances, and it was felt unfair that contracts should be able to do this. For example, if one of the parties to a contract was going to work in a way which would be dangerous, possibly injurious to life or limb, then that was held to be unfair. So looking at the restrictions that can go into contracts, look at what can be excluded, is an important issue. Now, in this class we're going to look at in particular two pieces of law, enacted law, which impinge upon contracts and which can help to determine the outcome from contracts, particularly in the situations, of course, where there are disputes. However, insofar as we're looking at two pieces of legislation, this particular video is complicated. So the video will take time to understand. You will need pen and paper. You need to go across it several times, make your own notes, do it slowly and try to work out what's meant under each part. You will not be examined on the particular sections of the Act or on the details of the Act itself, but they are mentioned throughout the video. But it is complicated and it will be difficult to follow in parts. So it's wise to make sure you are prepared to take on this particular video and pen and paper ready, make your notes, stop the video, return, do some additional research and reading into the area, pad out your notes and see what you can understand from what we're about to do. So in terms of complexity, you have been warned. Now, once it is decided that the exclusion clause is a term of the contract, it is necessary to consider the effects of the Unfair Contracts Terms Act 1977, this of course is in the UK, and the Unfair Terms in Consumer Contracts Regulations 1999. So if an exclusion clause is deemed to be a term, is a term of a contract, then it's necessary to see what the effects will be of that exclusion clause. Is it valid? Is it permissible to have that particular exclusion clause? That the contract is excluding certain outcomes or certain possibilities. Is it fair and right that the contract should be able to do that? And how does that proposal square with the two acts, or the act and the regulations that I've mentioned here in on this slide? So let's start by looking at the Unfair Contracts Terms Act 1977. Now, the important sections of the Unfair Contracts Terms Act 1977 apply only to business liability. So we're here exclusively dealing with business liability. So nothing between people, no personal contracts are being discussed here. It's a business situation. So Section 2.1 provides that liability for death or personal injury from negligence can't be excluded. So you can't draw a contract and in the contract say that the contract excludes any liability for death or for personal injury. So those can't be excluded in a contract. Section 2.2 addresses the liability for damage to property through negligence. So property is also dealt with. Such damages may be excluded if the term was reasonable. So the court will always look to contracts to see what the intention of the parties to the contract were and whether their intentions were reasonable, or were they quite extreme requirements? So the courts interpret contracts in terms of reasonableness. Now, the Unfair Contracts Terms Act 1977, well, unless the exclusion clause is reasonable, Section 3, liability for breach of contract may not be excluded where the party is either dealing as a customer or dealing on the other party's standard terms. So it's not possible to exclude liability in contracts if one of the parties is dealing as a customer or a consumer, or also dealing on the other party's standard terms. If they're meeting the standard terms of the contract and dealing on that basis, then liability cannot be excluded. Section 6 of the same Act prevents liability for breach of the statutory terms implied by the Sales of Goods Act 1979 from being excluded by any contract term. So it cannot be excluded as against a consumer, but can be excluded as against non-consumers if the term passes the reasonable test. So in other words, other acts of Parliament impinge upon contracts also. So it's not right, or it can't be done to exclude liability if that exclusion goes against the Sale of Goods Act 1979. Section 7 allows liability for contracts for supply of goods, but not under a sale of goods transaction. So if the parties to a contract can deal, but it's not covered by the Sales of Goods Act, then they may be able to have exclusion clauses which cover a wide range of possibilities. Section 8 allows liability for misrepresentation to be excluded so long as the term satisfies the Unfair Contracts Terms Act 1977 requirement of reasonableness. So misrepresentation may be excluded if it's deemed to be reasonable. So the courts look carefully at the wording of contracts, try to determine what is reasonable, and if it deems a certain clause to be reasonable, then it may be possible that misrepresentation can be excluded on that basis. But it has to be reasonable. Section 11 gives the definition of what is reasonable. So the law goes on to state what it considers to be reasonable. Well, the reasonable test. So section 11.1 states it must have been fair and reasonable to include the term at the time of making the contract. In other words, there was no duress or there was no particular pressure put on one of the parties to accept a particular exclusion clause. So it was reasonable and fair at the time the contract was drawn up. Section 11.5. The burden of showing reasonableness is on the party seeking to rely on the term. So if one of the parties to the contract litigates, goes to law over some issue on the contract, and are relying on the argument that the term was not reasonable, then they must seek to justify that. And if a party is relying on the term being reasonable, they must show why it's reasonable. Section 11.2 refers to the guidelines in Section 2, so we'll just leave that. So the factors in the schedule are not limited. Guidelines are suggestions of factors to consider, but not exhaustive. So there's a schedule of factors, But of course it's not exhaustive. So schedule of factors to say what is reasonable, what should the courts look for, and it gives guidelines and suggestions of factors to consider. But that schedule is not exhaustive. It can't be. We live in a world where circumstances are changing, technology is changing, many aspects of our daily lives are changing. So it would be unreasonable to imagine that the Parliament could come up with an exhaustive list of what it considers to be reasonable. The guidelines include bargaining power of the parties, presence of inducement knowledge of the term, and practicability of complying with the terms. Now, whether the parties can comply with the terms, that's important. If the terms of the contract are such that the parties can't easily comply with the terms, then that's unreasonable. Or if it's the case that there was inducements at the start which led the parties to agree to the contract, but when the inducements were taken away later, the contract was deemed to be unfair. That would be unreasonable as well. So not all contracts are covered by the Unfair Contracts Terms Act 1977. Examples include contracts of insurance are not covered by the Act. Matters of intellectual property, I should say there, intellectual property, referring to formation of companies. These are not covered. International supply of contracts, again not covered by the Act. And there are various cases that have been brought forward to try and get redress under the Act, but also cases in contract which shed light on the impact of the Act on the law of contract. The Unfair Terms in Consumer Contracts Regulations 1999 was put in place to augment the Unfair Terms 1977 legislation. So it runs alongside the 77 Act. It doesn't replace it, it just runs alongside. The regulation applies only to contracts made between a business and consumer. Also applies to contracts to supply goods and services that are not limited to dealing with exclusion clauses. So the new regulation, the 1999 regulation, the Unfair Terms in Consumer Contracts Regulation 1999, tries to shed light on what is fair and reasonable in terms of exclusion clauses in contracts. Regulation 5.1, a contractual term has not been individually negotiated shall be regarded unfair if it is contrary to the requirements of good faith, cause an imbalance on the parties' rights, obligation arising under the contract. So if it imposes an obligation arising under the contract that is deemed to be unfair, then the contractual term is unfair. The contractual term could lead to a failure of the contract. So it would be deemed as a condition of the contract and therefore lead to a failure of the contract. Likewise, if it causes a gross imbalance in the rights of each of the parties to the contract, that again is unfair. One of the parties to the contract would be disadvantaged. Or if it's contrary to the requirements of good faith. Now, of course, if you look at this, you think, well, what is good faith? It sounds like a very complicated and abstract term. What is good faith to one person may not be the same to another person. So it needs to be a standardized term. If the term was drafted in advance, then it has not been individually negotiated. So that's another issue that needs to be considered. If the terms were drafted in advance of the contract coming into existence and signed off, so in other words, if the parties did not have a chance to reflect on the terms of the contract, and if they did not individually negotiate the contract with each other, if it was a standard contract perhaps, then that may be unfair because the parties have not given it due care and attention. It's for the seller or supplier to prove that the term was individually negotiated. So it's for the seller to, or the supplier to show that the contract is fair. Whether or not good faith has been breached, the courts will consider all the relevant circumstances. So good faith means acting honestly and openly. Lord Bingham said in the Director General of Fair Trading versus the First National Bank 2001 that good faith required fair and open dealings to avoid hidden traps for the consumer. If the term is regarded as unfair, then it's not binding upon the consumer. If it is possible without the unfair term, then the rest of the contract will still stand. So it may be that an unfairness is detected in a contract, but it's only one of the terms of the contract, and the rest of the terms of the contract may be deemed as fair, and therefore they will still stand. That part of the contract will remain in place. It's only the unfair part of the contract that would be removed. In addition to the regulation allows the Director General of Fair Trading to apply for an injunction to prevent an unfair term from being used in the contract. So the proposal to include an unfair term would be ruled out right from the start. Now Schedule 2. Well, Schedule 2 of the regulations, these are the Unfair Terms in Consumer Contracts Regulations 1999. This sets out examples of the types of terms that may be regarded as unfair. Some examples include obliging the consumer to fulfill all of his or her obligations where the seller or supplier does not perform his or her part of the contract. So that's clearly unfair. One side has to fulfill all of the obligations and the other side doesn't have to. Clearly an unfairness. Making the consumer subject to terms before he or she had the opportunity to find out about the contract was made, before the contract was made. So making the consumer subject to terms of the contract before the contract was made. So in other words, dating the contract backwards in time. The contract come into force on a certain date, but the contract said that the parties to the contract were bound by the contract before it came into existence formally. That would be clearly unfair because the contract didn't exist then. So there's a long list of issues associated with fairness. The regulation cannot consider the effect of core terms in a contract. So it doesn't touch the core terms. These are the conditions of the contract. These are the essential points of the contract. The regulation doesn't consider those. The core terms set out the contract price and the contract's main subject matter. Therefore, the regulations are not confined to deal with exclusion clauses. The regulations set out the whole framework within which the contract should be drawn. Now, problems with the regulation. Well, the regulation overlaps with the Unfair Contract Terms Act, 1977. So there is significant overlap between the two. It's also too broad in terms of language. It attempts to do a lot. It attempts to define fairness, for a start, and fair terms, and give examples and schedules. What is reasonable? It tries to define and give guidance in terms of reasonableness, and that's a very complex thing to do also. The reason for the regulation is unclear at the moment. It needs to perhaps go back through Parliament and perhaps be incorporated into a new contract law, which would incorporate the 77 and the 99 attempts. The regulation could potentially have a wider effect on other aspects of law, because if reasonableness is defined within this regulation, the 99 regulation, then reasonableness could be applied in other areas of the law. So it could have an impact elsewhere in the legal system. So, as I said at the outset, a complicated class, many issues to consider, and I think what you should really pick up on here is looking at what is meant by reasonableness, what is fairness in contracts, in what ways can contracts be repudiated, looking at the impact of law in giving guidance on fairness and reasonableness, and seeing what the issues are in trying to codify these issues in law and trying to write them down. As I said, the impact on other areas of law, for example on negligence or on other areas of commercial law. So it's wise just to think wider on these areas. Here are some seminar type questions that you may want to attempt and have a look at to see if you understand the issues associated with this quite complex area. So work over them yourself and perhaps talk to your peers and colleagues about the issues and see if you can come up with a list to resolve these type of questions. But that's all I'm going to deal with here, so let's leave it at that and say thank you for watching.